Yes, Mr Lewis, I understand you've been successful in settling the appeal.
My lords, yes, firstly, good morning. I appear with Oscar Davis for the appellants, my other friend Mr Ray for the respondents. The parties have worked extremely hard over the last 2 days, and literally walking into court, I was told they'd managed to reach settlement. I've received electronic copies of orders which have been forwarded through to you, which I'm just making my way through now. The parties would be most obliged if you would be prepared to approve those orders this morning.
Well, we have two, I hope, minor comments on the orders which we've been provided with, or at least the
Yes.
Court of Appeal order. We're not concerned with the order
Indeed,
of the court
one
below. And that is that first, we understand that claimants 2 to 5 have disappeared from this case, in which case it simply ought to be headed Aries Robotics PLC and delete the others.
Indeed.
McRae doesn't agree.
And persons or persons unknown ought to be described in the same way as they are now in the claim, so responsible for demanding money from the claimant.
In the way that has been described in the High Court.
So that corresponds. Is that acceptable to you?
I suppose that, say for this, the appeal is live on behalf of all of the appellants, although below they've disappeared.
Well, if they're no longer parties to the action, how can they be pursuing an appeal?
My lord, yes.
Right. Okay, Mr McRae, do you want to say anything about that?
Thank you, my lord.
If it's easier for you to sit down, even though you're not going to be on your feet for very long, please do.
That's very kind. Formally, my lord, I understand that those parties do remain party to the appeal. I understand the unusual situation that presents, and that's certainly a point I was going to take during the course of my submissions, but formally, as I understand it, all 5 appellants remain on the file as appellants. So to the extent that it's necessary to settle as regards all of those parties, it would be helpful to ensure that the settlement is complete as regards all of them.
Aren't they deleted on the amended claim form?
They are.
That's right, my lord. Since the permission to appeal was given, an amended claim form has been filed, which deletes several of those parties. But I'm not sure that my other friends have yet regularised the position as regards.
I suppose it could be said that since you don't need a claim form in order to be an appellant on an interim application, that's not the answer.
That would be my submission, yes, my lord. In the interests of clarity and certainty, we would prefer that, given formally, as we understand, unless my learned friend tells me some administrative steps have been taken, that all 5 appellants remain on the record as parties to the appeal. We would prefer that the consent order speak to the breadth of the current status of the parties.
Do you have instructions, Mr Lewis, on behalf of claimants 2 to 5?
I do.
I wonder, always a danger of the court trying to draft things on the hoof, but I wonder whether Ms McRae's objection would be resolved if they were deleted from the heading and there were to be a recital and upon those parties, which could be named, having ceased to be parties to the claim but agreeing to be bound by this order, which would mean that they were Ms McRae's objections, I think, would then disappear, but it would be conceptually a little bit tidier.
Well, my lord, I'm content with that. In fact, you've not seen the confidential schedule that deals with it in that way. We can pick up the wording from the schedule and put it into the recital of the order before this court.
Any problem with that, Ms McRae?
Not for my part, my lord. I think it's an elegant suggestion, as long as those parties are bound by the terms.
Yes, well, that's what you want to achieve.
And that's certainly the intention.
Yes. You happy with that, sir?
Yes, sir.
All right. Well, if you would like to resubmit the order in those terms, as we've discussed, we will make an order in those terms.
And just sorry it wasn't done sooner.
Well, in that connection, there is one other point I want to mention, and that is to draw your attention to note 52.23.7 in the White Book on page 1928, which says if negotiations are in progress, which may well lead to settlement of an appeal listed for hearing in the near future, again, the Court of Appeal should be informed promptly. Such information will be treated as given on a without prejudice basis. The listing will not be entered until it is confirmed that the application or appeal will be withdrawn. And there's a reference to a case. You've told us you've been working hard, and I understand that, for the last couple of days.
Yes.
It seems to me the court could and probably should have been notified that this was a case which might well disappear. In the event, it might not have made all that much difference, as it's only in the last few minutes that you have been able to settle the appeal, but that's a paragraph which is there to be complied with when those circumstances arise.
It's an entirely fair point.
Very good. All right. Well, you let us have an order, and that will dispose of the appeal. Thank you both very much.
Thank you. Okay, fine, we'll just go. So, slight amendment.